The third challenge of corruption is the judicial perspective as the challenge of corruption, right? Now, if we see, the first is the contempt of court. Now, the Indian court is heavily criticized for its, you know, corruption and its inefficiency due to slow process. Now, the problem is citizens are unaware of their rights and using this benefit, the judicial officers they charge an extra money, a bribe for speeding up their trials. All right. Secondly, the judiciary, the judicial officers, they also are involved in questionable judicial verdict, and they pressurize the people to accept their verdict. And since people are unaware of their rights, they make this if the citizens don't follow it, they are punished by the contempt of court, right? So what is in need of our is we need to detect and curb this judicial misconduct. Firstly, we need to encourage the complaints and impartial probe, right? Secondly, the power of contempt available to judiciary, it can be rationalized, right? If institution of judicial ombudsman, right, it takes the case against the judicial officer, right, or the judge for that matter, for any verdict who by which the person who is penalized, he questions these courts. So judicial ombudsman can be an mediatory body or a body which can look into the case, not the judiciary itself, okay, on behalf of a great citizen, institution of judicial ombudsman, right? Now, the second is the second challenge of corruption from judicial perspective is that judiciary must conduct itself in a manner that is, unambiguously seen as being a reproach. That is, somebody doesn't complain or somebody is not very disappointed by the judicial conduct, okay, both legally and morally. All right. That person both legally and morally should not be disappointed with the conduct of judiciary, right? And it must be able to impose upon itself strict measures of accountability, allowing also for the healthy contribution from agencies external to its system. This can be achieved by prescribing broad ethical standards and guidelines which go beyond the legalities to go on the conduct of judges. An instance in this regard is the restatement of the values of judicial life, Supreme Court 1997. Right? Let's there are around 15 to 16 points. Let's see them. In 1997, the Supreme Court adopted a charter called the Restatement of the Values of the Judicial Life to serve as a guide to the be observed by judges, essential for independent, strong, and respected judiciary, indispensable in the impartial administration of justice. It is a complete code of the canons of judicial ethics. It is not meant to be exhaustive but illustrative what is expected of a judge. Okay, just an illustration, just an indication. First, justice must not merely be done, but it also must be seen. The behavior and the conduct of the members of higher judiciary must reaffirm the people's faith in the impartiality of the judiciary. Accordingly, any act of a judge of the Supreme Court or High Court, whether in official or personal capacity, which erodes the credibility of the person has to be avoided. Second, a judge should not contest the election to any office of a club, society, or other association. Further, he shall not hold such elective office except in society or association connected with the law. Third, close association with individual member of the bar, particularly those who practice in the same court, shall be eschewed. Fourth, A judge should not permit any member of his immediate family, such as spouse, son, daughter, son-in-law or daughter-in-law, or any other close relative, if the member of the bar to appear before him or even be associated in any manner without a cause or to be dealt with him. Fifth, no member of his family who is member of the bar shall be permitted to use the residence in which the judge actually resides or other facilities for professional work. Sixth, a judge should not practice a degree of a loftiness consistent with the dignity of his office. Right? Seventh, a judge shall not hear and decide a matter in which a member of his family, close relation, or friend is concerned. Eighth, a judge shall not enter into the public debate or express his views in public political matters or on matters that are pending or likely to arise from judicial determination. Ninth, a judge is expected to let his judgments speak for themselves. He shall not give his interview to the media. 10th, a judge shall not accept gifts or hospitality except from his family, close relations, and friends. 11th, a judge shall not hear and decide a matter in which a company in which he holds share is concerned unless he has disclosed his interest and no objections to his hearing and deciding the matter is raised. 12th, a judge shall not speculate in shares, stocks, or the like. 13th, a judge should not engage directly or indirectly in the trade or the business either by himself or in the association with any other person. 14th, a judge should not ask for, accept contribution or otherwise actively associate himself with the raising of any fund or for any purpose. 15th, a judge should not seek any financial benefit in the form of perquisite or privilege attached to his office unless it is clearly available. Any doubt in this behalf must get resolved and clarified through Chief Justice. 16th, every judge must at all times be conscious that he is under the public gaze and there should be no act or omission by him which is becoming of the high office he occupies from the public esteem in which that office is held. And finally, lastly, is the judicial appointments and removal. Right. The thing is, the judicial independence, it's very important to maintain the public trust and public fairness, right? And if we see, in order to maintain judicial independence, power vested in judiciary should be final and unreviewable, right? And it is also very important that the power vested must not favor only the members, right? Members of judiciary and such powers don't self-indulge, right? A vital component then is the quality of individuals who are chosen to serve as judicial officers as reflected through their appointment and removal. However, the collegium system remains largely opaque with very little information available outside of the judiciary regarding the criteria on the basis of which appointment was made. Even in the removal of a judge, the preponderance of the judiciary remains high, since any removal motion passed by a House of Parliament has to be investigated by a committee of three judges of the Supreme Court and a distinguished jurist before any further action. In this regard, transparency and impartiality can be incorporated in the proceedings through constitution of a multi-member body that gives due representation to diverse organs and levels of judiciary itself. Main point, the power, first, the collegium system should be made more transparent. Let the information also come to the public. And secondly, the powers must not be self-indulging, right? That's all. Thank you.